This is the lecture on wills and trust, and it's taken from chapter 39. That's the PowerPoints from the 6th edition of Business Law Texts and Exercises by Miller and Hollowell. And I know that we're using the 7th edition, but my copy of the PowerPoints for the 7th edition is corrupted, and so I'm using the next best thing, which is the 6th edition. So please bear with me in that regard. Now, let's talk about the learning outcomes that we wish to have as far as this particular lecture. We're going to outline the requirements of a will. We're going to discuss the methods of revoking or modifying a will. We're going to describe the distribution of the property of a will of a party who dies without a will. That's called intestate succession. We're going to list the essential elements of a trust. We're going to state how different types of express and implied trust are created or arise. Okay, now a will is a final declaration of how a person wants to have his property disposed of after death. And the parties to a will are the either the testator, which is the male version of that party, or a testatrix, the female version. We have the executor, that's the person named in the will, or the executrix if it's a woman. We have administrator, or an administrator, and that is a person that is appointed by the court, and that's usually in a intestate succession situation. So generally in a will there are gifts that are given. So we have a devise, which is a gift of real estate, basically real property, and we have a bequest or a legacy. That's a gift of personal property. Gifts can be specific, that describes the particular property. They can be general, which specifies value of property, or they can be residuary, which pays for the debts after the gifts are made. The requirements of a will. Number 1, capacity. And we talked a lot about this in our contract area, that the testator must have legal capacity at the time the will is made. The testator must be of sound mind, and that's one of the basic requirements of contract, in contract law, if you recall that when we studied that early on during the semester. Wills must be written. The will must be in writing. Okay, a holographic will is in the testator's handwriting, and so that is basically one that's written out. A lot of times we call that perhaps maybe a battlefield type will, where you have the soldier that's out in the battlefield writing out in his or her own handwriting how his or her property should be disposed of in the event the testator doesn't make it back from the battlefield, and we call that holographic. Holographic wills do not have to be signed. Holographic wills are signed. Holographic wills do not have to be witnessed, and that's what I was going to say. But the requirements of a will whether it's holographic or whether it is a regular will that might be prepared by an attorney, is that it must be signed and signed by the testator. In addition, the regular type wills, as stated before, must be witnessed. That's a test to be genuine by at least 2 competent witnesses. So that doesn't mean that the witnesses agree with the will or understand that what is in there, but that they have witnessed the testator sign the will, and also witnessed the testator to some extent stating that this is his or her last will and testament. Publication, and that's similar to what I alluded to just a minute ago. The will is published by the testator by an oral declaration to the witnesses that the document they are signing is in fact his last will and testament. We cannot validate a will if there has been undue influence or improper pressure on a testator causing him to change his will and property distribution. And this happens, as we know, a lot of times with elderly people, that sometimes there may be undue influence if it's discovered that the person has a substantial amount of property and someone wants to get them to give it to them, and they use undue influence to do so. The court rules on issues of undue influence. It's inferred when the testator's plans of distribution of property favor a non-relative who is in constant close contact and in a position to influence the making of the will. And that might be someone like a caregiver, or someone who might be, say, a friend or neighbor or whatever, and the court might presume that there may be undue influence on the behalf of this other party that is not a relative. Now, revocation of wills. A will can be revoked by the act of the testator, a physical act such as destroying the will, or subsequent writings. So the testator makes another will, and that will revokes the prior will. And generally there's a statement in the will to that effect. It could be revoked by operation of law, due to marriage, due to divorce, or due to children, having children. So there could be some revocation there by any of those particular methods. Now, if we deal with learning objective 3, we're talking about intestacy laws. And these laws regulate how property is distributed when a person dies without a will. And we know that it's very important that a person leave a will so that they can have their property disposed of. But in the event they don't, then they leave the distribution of the property to the state. The state decides, according to the laws of intestate succession, how the property is going to be given or passed to the next of kin and so forth. So the order of distribution is basically the debts. The decedent's debts are paid first. Then it goes to the surviving spouse and children. If no surviving spouse or child, then to grandchildren, then brothers and sisters, and then parents. And it can also eventually go down, if they can't find any of the people that were just described, it can go to basically next of kin, dealing with, say, as far down as cousins and so forth, or uncles, or people that are fairly remote as far as the bloodlines are concerned. Now, intestacy and the surviving spouse and children. When that's the situation, then what happens is that you have a surviving spouse receiving the homestead and a share of the estate as follows. They get 1/3 of the estate if there are two or more children. The surviving spouse gets 1/2 of the estate if there's one surviving child. The entire estate they get if there's no children or grandchildren. So you can see where that might be. It might be very important to have a will, because if you have a situation where there are children involved and no will, then the spouse does not automatically receive the entire estate. Then it may be divided among the children, as indicated before, with 1/3, the surviving spouse getting 1/3 or 1/2, and that could create some problems or issues with the family. But that's unfortunately what happens when you leave this situation up to the state. Okay, so if it goes to grandchildren's, there's a couple of different rules that apply. Per stirpes distribution. That's the method of dividing an estate share by which a class or group of distributees take the share that their deceased parent would have been entitled to inherit had the parent lived. So basically they step in the shoes of their parents. Okay, in a per stirpes distribution. We also have the per capita distribution. Each person takes an equal share of the estate in a per capita situation. And this is per stirpes distribution type of diagram. It shows, and you have this in your book as well, and it shows the deceased, Michael's deceased, Scott, who's a son or a son, and Jonathan's the son, the deceased, and then you have basically the in per stirpes, since Scott had 2 children, you see, then his children get 1/4 apiece. With Jonathan has 1 child, and so there's one. So that's 1 grandchild of Michael, and so Paul, who is the grandchild, would get 1/2. And under per stirpes, then that is how that would work. Now, under trust basically is a right of property, real or personal, held by one party for the benefit of another party. And trust can be utilized to attempt to avoid paying a lot of taxes and probate, and to basically shelter the property from others that might attempt to get access of the property. And so we talked before about corporations, and it's kind of like a way to protect the assets that are passed down. And the trustee holds the property on behalf of the beneficiary. So in every trust, you're going to have a trustee, and they act with honesty, good faith, and prudence in administering the trust, and must exercise a high degree of loyalty toward the trust beneficiaries. And we've heard of that type of situation before, and we call it a fiduciary relationship, and we'll say that that's the same thing that we have here. It's a fiduciary relationship that the trustee has. The elements of a trust. Trust is designated, has designated beneficiaries, designated trustee, funds sufficiently identified to enable title to pass to the trustee, and actual delivery to the trustee with the intention of passing title. So Exhibit 39.3 shows a trust arrangement. The person creating the trust is what's called the settlor. That would be James in this particular situation. And James creates the trust, and then the trust property is a farm, and then that legal title goes to the trustee, which is the bank in this situation, the First Bank of Minnesota, and so they have legal title. Equitable title then vests with the beneficiaries, and so the trustee is holding this property for the benefit of the beneficiaries, who in this particular situation are the daughters. And we can have an express trust, what we call an inter vivos, or a living trust, created by the grantor during her lifetime, and it's revocable. So during the lifetime before the settlor dies, the settlor can establish this trust, which is revocable, and it basically they put the property in the trust, and it protects that property from being invaded by other individuals or other sources. We can also have what's called a testamentary trust. It's created as part of a will, comes into existence at the testator's death. These testamentary trusts generally work hand in hand with the will, and so generally at the time of the death of the settlor, then the will is referred to as being the property, or actually the will states that the property is to be basically the property is in the trust, and the terms and conditions that are administered are subject to what is spelled out in the provision of the trust. And so they work hand in hand with the testamentary trust and the actual will itself. And there can be implied trusts or constructive trusts that arises by operation of the law in the interests of equity and fairness. Resulting trusts arise from the conduct of the party, and as was stated before, in some situations dealing with partnerships and things like that, the court can infer in those situations, as well as with a resulting trust, that the conduct of the parties is such that we have a resulting trust. Okay, and that concludes our slideshow dealing with the situation of wills and trust. Now, I will point out as well that we have there's additional information that is on Blackboard dealing with wills and trusts as well, and so you should review that also prior to taking the quiz that is on Blackboard for you. Thank you very much, and good luck to all of you.